Hello, I'm Tim Dodge, the Assistant Vice President of Research for the Independent Insurance Agents and Brokers of New York. And I want to talk to you for a few minutes about a new law that's taking effect in New York State on July 28th that will place some new limitations on the way that organizations can use and demand documents that are called certificates of insurance. A certificate of insurance is a summary of an organization's insurance coverage. It provides basic information such as the name of the insurance company, the policy number, effective and expiration dates, the amounts of insurance provided, and so forth. Now, it is a means of conveying information about an organization's insurance program. It's not a contract, although historically some organizations have tried to treat it that way. The law that's taking effect on July 28th will put new limitations on what organizations can demand on certificates of insurance. Frequently an organization will ask for a certificate from a contractor that they've hired or from a vendor or someone else that they're doing business with, a tenant perhaps as well. So what are those new restrictions? It will be impermissible to refuse to award someone a contract, or refuse to allow them to start work, or refuse to pay them for work already done, simply because that other organization, the contractor for example, has not submitted a certificate of insurance, unless that certificate is one of three types. Number one would be a certificate form issued by the insurance company providing the coverage. Number two would be a standard form published by an organization such as Accord or the Insurance Services Office. Or number three, any other certificate form that has received approval from the New York State Department of Financial Services. Many organizations, including government agencies and general contractors, have their own certificate forms that they prefer to have contractors use. If they want to continue to use those forms, they will need to get them approved by the New York State Department of Financial Services. A second restriction is that starting July 28th again, it will be impermissible to require certain wording to go on certificates of insurance if that wording is not on the policies listed on the certificate. So here we're talking about special terms and conditions and provisions, warranties and guarantees of coverage, certifications by the insurance brokers, and so forth. If that wording is not on the policy, once the organization requesting the certificate finds out that the wording is not there, it can no longer require that wording to go on the certificate. Now, the law still permits you to set minimum insurance requirements for those businesses with whom you are working. So if you are putting a project out to bid and you want the contractors to meet certain minimum insurance requirements, you can still put that in the bid conditions. What an organization will no longer be able to do is to stop everything because of missing wording on the form. Lastly, the certificate of insurance cannot be used to change the insurance policies in any way. Again, they are just a tool for conveying information. They're not a means for changing the policy, and the new law makes that clear. Now, the law gives the State Department of Financial Services the ability to enforce this law by assessing fines of up to $1,000 for a first offense and $2,000 for subsequent violations. So it's really important that any organization that requests or requires certificates of insurance be aware of these new restrictions so that they don't inadvertently incur fines. If you need more information about this law, we have plenty available at the IABNY website at www.iabny.org/certificates, including a fact sheet and the complete text of the law. It's only a couple of pages long and not that hard to wade through as laws go. I hope you found this video helpful. Thank you for your attention. I'm Tim Dodge.